Well, good morning. Welcome to this webinar, the latest in our kind of series of health and care conversations. Today's topic is data subject access requests in an employment context. Delighted to be joined by Helen Tringham, a partner, and Claire Williams, a principal associate, both of whom specialise in data protection issues. I'm Stuart Craig. I'm an employment law partner. So do link in with us as per the slide there. So just in terms of a summary of what we're going to cover this morning, I've set those out on the slide there. So first of all, what are the key things you need to think about when you're faced with a data subject access request? What are the implications for GDPR and subject access requests in the context of settlement agreements? What are the exemptions that you might be able to apply, and how do you best go about applying them? What are the circumstances in which employees come to make data subject access requests, and what kind of implications do those circumstances have? And then also a few points about minimising risk in employment investigations. So that's kind of today's agenda. And so with that in mind, I'm going to hand over to Helen now to look at some of the key issues, first of all, key terms. Sorry.
Thank you, Stuart, and good morning, everyone. So before we look at this topic in detail, I'm going to look at some of the key terms that are used in the data protection world in relation to subject access requests, just to make sure we're all on the same page. So the first key term is personal data, and that's anything that could identify a living individual. So it needs to be about a living person, and that person needs to be identifiable. That means a subject access request can't be made on behalf of a person who has passed away, as their data no longer constitutes personal data under the UK GDPR. In relation to what is identifiable, personal data will include contact details, training records, financial and pay details, and anything about a person's family or lifestyle. So essentially anything about an employee is likely to be their personal data. You don't need to see a person's name in a document for that person to be sufficiently identifiable from the content of the document. A person is identifiable if they can be properly distinguished from other individuals. So, for example, if one of you were to describe me in an email after this training as the person with long hair from Mills and Reeve who delivered the training today, you haven't used my name, but I am identifiable, so it's my personal data. The next key term is data subjects. They are the individuals who enjoy the rights under the UK GDPR, which includes the right to make a subject access request. Both employees and patients are data subjects. And finally, the UK GDPR applies to all data controllers, and your organisation is a data controller in every scenario where it determines the purpose and means of processing of data. And in today's training, we're looking from the perspective of a data controller and what it needs to do and think about when it receives a data subject access request. Next slide, please. So data subjects have multiple rights under the UK GDPR, and the most significant is often the right of the data subject to access their personal data. So what is the dreaded subject access request? Well, under Article 15 of the UK GDPR, which is set out on the slide, a data subject, for example, an employee, has a right to obtain from a data controller, first, confirmation that their personal data is being processed by your organisation. Second, access to a copy of their personal data, usually free of charge. And thirdly, certain additional details about how their personal data is handled, which are at a fairly generic level that you would expect to be provided in a privacy notice. The right is not to be provided with a copy of specific documents, but instead is to see the parts of the documents that contain their personal data. It seems fairly simple, but as you probably know, processing a subject access request, or a DSAR, as they're often called, can be resource intensive and trigger many questions and issues. They can also be very expensive. So in 2017, it was reported that the Nursing and Midwifery Council had spent £240,000 in legal fees dealing with a single subject access request. There's also the need to get it right first time. If you don't comply, a requester can either go to the Information Commissioner's office, or they can complain to the courts and try and force you to complete the DSAR properly. So why does the right exist? Well, according to Recital 63 of the UK GDPR, the intention behind the subject access request is to enable a data subject to be aware of and verify the lawfulness of any processing of their personal data. Essentially, the GDPR recognised that data subjects had an ever decreasing access to and understanding of what was happening with their personal data. And the legislation has forced the balance back towards some sort of equilibrium. So moving on to the next slide, what should you do when you receive a DSAR? We've set out on this slide the steps you should take immediately. So first, make sure it is a DSAR. You should check whether it should be dealt with under any other process, for example, under the Freedom of Information Act. Practically speaking, it means writing to the data subject to tell them how you've understood their DSAR and to ask them to respond if you've misunderstood their request. In any event, it's good practice to acknowledge receipt of a DSAR. Next, you should consider whether you should ask for ID. So requests to provide proof of ID can only be made if you have reasonable grounds for doubting that the employee is the one making the request. This is because requesting ID pauses the clock for responding to a DSAR. So employers should not do this with an employee who is using their work email address to submit their request, or where they're using contact details which you're already aware linked to that employee. You must respond to the DSAR without undue delay and within 1 month of the receipt of the request. There are ways to pause or extend the deadline, but the Information Commissioner's Office is very clear that most DSARs should be responded to, including all disclosure within the 1 month time limit. And finally, just a reminder that DSARs are currently motive blind. It doesn't matter if there's ongoing litigation and the data subject is using it as a fishing expedition. You have to respond to it unless it is manifestly unfounded or manifestly excessive. Next slide, please. So I'm now going to look at the practical steps to take in responding to a subject access request before handing over to Claire, who's going to look in some detail about the exemptions that you may be able to engage. So the first step is to narrow the request if at all possible. So searching for and handling personal data can be extensive, laborious, and very time-consuming. The data subject is under no duty to agree to narrow the search. However, the case law in relation to the old regime says that your search for their personal data has to be reasonable and proportionate. Therefore, if you receive a request that's likely to generate a significant amount of documents, it may be sensible to write to the requester asking for their help to locate their personal data by searching specific mailboxes or by using key terms or date ranges. If you can agree keywords with the requester, this may cut down your work, sometimes significantly. Next, know where the personal data is held within the business. You'll only have 1 month to respond, and therefore it's important to know where personal data may be held. So, for example, emails, paper files, electronic systems. This can be planned for in advance by undertaking an internal audit to produce a roadmap of where personal data is held. Next, consider extending the deadline. This can only be done when the preliminary search has been completed. In order to do this, you'll have to argue that the request is complex, and that will provide you with up to an additional 2 months to respond to the request. The ICO has some guidance on what it considers to be a complex request, and that includes matters such as where there are technical issues because the data has been archived, or where there's been a need to obtain specialist legal advice. The ICO has said that a request is not complex solely because the individual requests a large amount of information. So in other words, you can't have the additional 2 month period just because there are a large number of documents to review. In any event, it's good practice to get something to the requester within the original 1 month period, for example, straightforward records. Next, consider any exemptions. There are various exemptions that can be applied to limit what is provided, and you need to allow sufficient time to consider those carefully. And as I said, Claire's going to look at exemptions in some detail in a moment. So to redact or to extract, as we've mentioned, the data subject is only entitled to the parts of the documents that contain their personal data. This can mean there's often long email chains where only a small part of the chain relates to them. As a data controller, you have a choice to make as to whether you redact all of the irrelevant data, and in practice that means putting black boxes over the irrelevant parts, or extracting the parts that are relevant into a fresh document. You'll appreciate that lots of redactions can often cause more intrigue, as the data subject often believes that the juicy bit they really want to see is covered by one of those black boxes. So think carefully about redaction or extraction. Extraction is always sensible when you have a large spreadsheet with only one entry relating to the data subject. Good record keeping is paramount, so make sure you know where was searched and what was sent to the data subject. This is important should the individual challenge what's been provided. If the Information Commissioner was to investigate, the GDPR expects you to have good records of the subject access requests that have been made and the responses that were sent. Other people's personal data, you need to be really careful about third-party personal data and make sure you allow sufficient time to consult third parties about their views. Again, Claire's going to talk about that in more detail. And the final point I wanted to make in relation to responding to a DSAR is in relation to courts and tribunals. So remember that what people are entitled to in a court case or a tribunal claim is different to what they're entitled to under a DSAR. The court or tribunal rules will dictate what an individual is entitled to receive in respect of each process, and the GDPR dictates what a data subject is entitled to see under a DSAR. Having said that, it's really important to make sure that you're mindful of both processes. For example, it would be far from ideal if a document was disclosed in response to a DSAR that was then not disclosed in a tribunal claim when it should have been. That will lead to the requester losing trust in your processes and increase the risk of a further claim or complaint. So moving on to the next slide. We wanted to talk about settlement agreements and DSARs as an issue that we see very frequently. What we see is that a DSAR is raised as part of a claim or a grievance. The claim or grievance is settled, and the organisation wants the DSAR to be settled or compromised as part of the settlement agreement. There are a few key points to make here. So you cannot prevent a person from making a DSAR or from exercising their data protection rights. They're freestanding rights that data subjects enjoy that cannot be contracted out of. Next, you should not prevent them from reporting any concern about your compliance with the GDPR to the ICO. To do so is highly likely to be criticised by the Information Commissioner. Indeed, regulators like the Information Commissioner expect data controllers to make clear to the data subject their right to complain to the regulator. So what this means is that you should not seek to prevent an individual from making a future subject access request, and any settlement agreement should not prevent a complaint to the ICO. At best, you can ask in the settlement agreement for acknowledgement that the current subject access request has either been withdrawn or completed to their satisfaction. Then if a complaint is made to the ICO, you have a clear paper trail as to why the DSAR was not completed. A further consequence is that you can't stop a data subject making a subject access request the very next day after the settlement agreement has been entered into. So on that cheery note, I was proposing to hand over to Claire, unless there's any immediate questions.
There was one kind of point that's come through, Helen, and it's probably a point for clarification, and that's the manner in which subject access requests can be made. So do they have to be in writing? Can they be by email? Can they be made verbally?
So they can be made in any sort of written format. So that can be on social media or in an email. If you receive an oral request for a subject access request, I think it's very good practice to acknowledge it as a subject access request, because clearly that person is seeking to exercise their rights. So to ignore it in some way might cause further difficulty. So I'd certainly treat it as a subject access request.
Okay, thank you.
All right. Thank you, Helen. So now we're moving on to looking at the exemptions to disclosure. A DSAR might require the disclosure of significant content from HR documents. And that content, as we've mentioned, can either be supplied by providing original documents with all the irrelevant and exempt material redacted out, or by extracting any personal data that is there into a new document, which you then hand over to the requester. The UK data legislation does recognise that in some circumstances, you might have legitimate reasons to withhold data. In particular, the right to obtain a copy of personal data must not adversely affect the rights of other people. So where an exemption applies to the facts of a particular request, a data controller may refuse to provide all or some of the requested information. All depends on the circumstances. Where the personal data of the requester is being withheld from disclosure, you've got to be very clear as to which exemption is applying, and you need to inform the requester of the exemptions that have been applied. There is always a risk that your use of exemptions will be challenged. So, as Helen mentioned, keep very good records about your decisions in this area. So, the most common exemptions, as you'll see, I've listed some on the slide, but on the first column, you'll see the first two items are in square brackets. That's because they're not technically exemptions under the legislation. They're just not within the scope of the GDPR right of subject access in the first place. So these are non-personal data and third-party data. So for non-personal data, that is literally anything that is not personal data. It's not covered by GDPR and it can't be requested under Article 15. It might be appropriate in some cases to include it in order that the data subject can better understand what they've received as disclosure, but it's not actually compulsory. For third-party data, there isn't a special exemption for joint third-party data, which I will explain in a moment, but the data subject is not entitled to receive data that is purely the personal data of somebody else, someone other than them. That doesn't mean you can never provide it, but to decide, when you're deciding whether to hand it over, you need to ask if providing the data would adversely impact the rights and freedoms of that other third party. When it comes to the actual exemptions, you do find these mainly in Schedule 2 to the Data Protection Act 2018. There are also exemptions in Schedule 3, which concern health, social work, education, and child abuse data. And there's even more exemptions in Schedule 4, which concerns disclosure that's prohibited or restricted by the law. So looking at the ones from Schedule 2, the first is the joint personal data exemption. You'll find it in paragraph 16 if you wish to look. And it's the one I mentioned earlier. It says that the right to data access does not oblige the data controller to disclose information to a data subject to the extent that doing so would involve disclosing information relating to another individual who can be identified from that information, unless that other individual has given their consent to the disclosure of that information to the requester, or it is reasonable to disclose the information to the requester without the consent of the other individual. And for that, you need to balance carefully all the relevant circumstances when you're making the decision. You need to look at a wide variety of factors. And according to both ICO guidance and relevant case law, a business that has received a DSAR must not apply a blanket policy of withholding the identities of other individuals when responding to a SAR, but must instead make a detailed assessment of the issue. So your detailed assessment will include things such as contacting the third parties to actually ask them whether they would consent to disclosure of their personal data. There may be reasons not to ask them, of course. It will all depend on the circumstances. Then we get legal professional privilege, which is at paragraph 9 of the relevant schedule. And that covers confidential conversations with lawyers or others which relate to litigation or legal issues. So the right of access doesn't apply to personal information that consists of information in respect of which a claim to legal professional privilege could be maintained in legal proceedings. In other words, it has to be something that your lawyers would actually be able to put forward to the court with a straight face. Or information in respect of which a duty of confidentiality is owed by a professional legal advisor to a client. Legal privilege comes in two forms. It's litigation privilege, which relates to communications about active or pending disputes, and legal advice privilege, which relates to advice received from your lawyer. If you want to use this exemption, please do be aware that the ICO expects you to be able to state how much of the data you reviewed was withheld on the basis of each type of legal privilege. So you need to know your justifications well. Legal privilege doesn't cover every conversation you have with a lawyer, so please be aware that simply copying lawyers in doesn't help. Instead, the solicitor or barrister in question needs to be approached to give legal advice or actually be giving such advice. And the burden of proving that data is privileged is on the data controller if that claim is challenged. The next exemption is at paragraph 22 of Schedule 2, and it's called management forecasts. So the right of access does not apply to any personal data being processed for the purposes of management forecasting or management planning in relation to a business or other activity, if the right of access being applied would be likely to prejudice the conduct of the business or activity concerned. From a HR perspective, in short, if you're planning a reorganization or maybe a redundancy process, you don't need to hand out data that actually impedes you from progressing that project. However, once the project is over, all bets are off. Paragraph 23 is the negotiations exemption. Again, Article 15 rights don't apply to personal data that consists of records of the intentions of the data controller in relation to any negotiations with the data subject, to the extent that disclosure of that information would again be likely to prejudice those negotiations. So if you're in settlement negotiations with an exiting employee or with an ex-employee, you don't have to disclose data that sets out your internal negotiation positions, your thinking, and your discussions on it. That would be unfair. You can't be forced to reveal your hand. Paragraph 24 is the last one that's commonly used from Schedule 2, and it's about confidential references. So Article 15 does not give a right of access to personal data that is a confidential reference given for the purpose, for multiple purposes, but mostly to do with education, training, or employment, placement as a volunteer, appointment to office, or the provision by the data subject of any service, say as a contractor or something. So as a general rule, we tend to remove confidential references from disclosure. But as a word of warning, the confidential reference needs to have remained confidential. And then on Schedule 3, as mentioned, specific to the healthcare sector, there is an exemption from disclosure under a DSAR it's called serious harm exemption. So where the personal data is health data or social care data, and disclosure would be likely to cause serious harm, in the opinion of what's called the appropriate medical professional, which is usually the last one involved or the GP or something, to the physical or mental health of either the data subject or another individual, then that data can be withheld from disclosure. It's not that common for this to apply to an employee as opposed to a patient, but you may have staff members who are both, or there may be occupational health records that need to be considered. All right, next slide, please. Right, there's a special complication for HR in healthcare as well, patient data. It's something we're going to look at more in the third webinar in this series, but as a potted summary, healthcare records are confidential between practitioner and patient, but patient incidents, near miss events, complaints, and even colleague disagreements will often stem from something to do with a patient investigation. With a patient. And so the investigation is likely to need to take into account at least some information relating to a patient. And where this is recorded and also constitutes the personal data of the requester, you need to consider what, if anything, has to be disclosed. It's possible to take that information into account and record it in investigation notes, provided that what is recorded is very limited to what is necessary. It's anonymized where possible. It's only processed or shared for the very limited purpose of carrying out the investigation. And the processing also needs to be done either in pursuit of a substantial public interest or because the law actively requires you to do so. So given the level of protection attached to patient data, it's clear that most patient data will be exempt from DSAR disclosure under the joint third-party exemption that we just talked about. But all instances where patient information is contained in HR documents and potentially disclosable under a DSAR need to be considered with particular care. And this is the best thing you can do to reduce the burden on reviewers for any subject access request is when you're doing such an investigation, include only the minimum amount of identifiable patient data as possible in any notes or other documents. Next slide, please. So with all that in mind, what sorts of things can we redact? But here's some made-up examples that would not be out of place in an investigation report relating to a medical practitioner. So for the first one, we have Leslie's manager reviewed the clinical records for each of the 5 patients. Leslie had not recorded adequate patient histories. For PL, there was evidence Leslie had prescribed inappropriate amounts of drugs. And for KT, a referral to dermatology was recorded, but investigation showed it was never sent. Things you need to think about here would be that Leslie's manager is identifiable, as he or she is mentioned by job title and reference to a subordinate. You might consider whether to redact out the identified details. But given there is reference to a manager who is engaged in managerial tasks and all the content is professional content, there's actually unlikely to be any issue or undue impact on the manager's rights to leave that information in. PL and KT appear to be patients, and the wording is about both of them and Leslie at the same time. So that makes it joint personal data. So you need to consider whether, in all the circumstances, it would be appropriate to provide it to Leslie. Clearly, Leslie needs to know what Leslie's accused of doing, but you have to take into account the duty of confidence owed to the patients. So we look at the content to see what can be removed in order to de-identify the patients while leaving enough for Leslie to actually understand what the allegations are. So in this case, redacting out PL's initials is probably enough to de-identify that data. Leslie still understands what's being said. For KT, the information given is both a referral to dermatology that was not actioned and initials. So to de-identify this data, I would remove both the initials and the word dermatology. The earlier reference to 5 patients is okay because it doesn't actually sufficiently identify any particular patient. Looking at the second paragraph, Leslie's colleague Susie raised concerns with the manager about Leslie's attitude towards patients and other staff. Susie had asked Leslie to clarify the treatment for one patient and say she was shouted at and called incompetent. Susie was quite tearful when recalling the events. For this, things to think about would be, first, we don't know whether Susie is senior at the same level with or junior to Leslie, and that's something to find out because seniority can affect the decision as to whether joint third-party data is to be redacted out. So let's assume Susie is junior, and maybe she could fear retaliation of some sort if Leslie finds out what she said. In that sort of case, the balance probably lies in favour of redaction. The reference to the patient here does not identify the patient, so you don't need to worry about patient confidentiality. And the last sentence is pure third-party data about Susie, and I would expect it to be redacted. So what will that look like? That's on our next slide, please. Like this. So the third-party data we think it's appropriate to remove has gone. The patient data is de-identified, but Leslie still understands what Leslie needs to know. And as a point on redaction, this should be done with specialist redaction software. Black marker pen can be seen through if you hold documents up to the light. And if you apply black boxes in Adobe, in some cases, a person can select all text, copy it, and paste it into a Word document, and they will be able to see the unredacted parts. Be very careful. Next slide, please. And now, as a final point, before I hand over to Stuart, you've collected the data, you've reviewed it, you've tagged it, you've extracted or redacted where appropriate, and you've just kept records as to everything you just did. And it's perfect. So now it's time to disclose the data to your requester. And this is a critical point because it's a point where things can go very wrong. It's vital to ensure you're delivering the disclosure to the requester in a secure way. Sending things through the post is not a good option, particularly at the moment, but generally also not a good option. The post is a mere processor. It is not liable if it loses your disclosure. So the best way to send the disclosure is via an electronic share file, which requires the requester to log in and download the contents. You upload the contents to the folder. You tell the requester they have a specific length of time to download it. They have to actively go get it. If the requester does want you to send it in hard copy, maybe they need it for some reason, make sure it's via signed for delivery, or the requester is required, if reasonable, to actually come and collect it from you. Cut out the middleman. Also, make sure that only your DSAR disclosure is included in any hard copy files or electronic files or envelopes. I've actually seen a few data breaches that were literally the inclusion of someone else's document in a DSAR response because something else was accidentally scooped up from the desk when the papers went into the envelope. So again, on that cheery note, I will pass on to Stuart.
Thanks, Claire. A couple of kind of questions that have come through on your section, which I think it's probably worth dealing with now. So one is, you've got your DSAR and you've provided the kind of data in response. In addition to that, what other kind of information do you have to provide for instance, the purpose of the processing, how long the data is being held for in terms of the retention period, how securely it's being kept, and so on. So what else do you need to tell the requester as well as giving them the data?
How are you going to go?
Yeah, I'll pick that one up. I don't know about you, Stuart, but I do have my copy of the GDPR in front of me. So under Article 15, they're entitled to specific bits of information. So the person who's posed the question is right. They're entitled to the purposes of the processing, the categories of personal data, the recipients or categories of recipients. And that's really important because sometimes we find that requesters want to know the precise individual who's seen a certain email, but actually the GDPR is a little bit more generic. It says the recipients or categories of recipients that have received the personal data. Article 15 also says that they get to know the envisaged period for which the personal data will be stored, the existence of their other rights, so the right to request erasure, and also their right to lodge a complaint with the Information Commissioner. So I think the one part of the question that's been posed was whether or not they get to know about the security of data. That's not actually a list of things they get under Article 15. But indeed, as I mentioned earlier, a lot of what's covered in Article 15 is normally the stuff you'd expect to see in the privacy notice of the organisation.
Okay. And then finally, for either of you, just a question about the serious harm exemption. I'm probably kind of practically applying it. So how do you advise the data subject that any information is exempt under the serious harm exemption without alarming them? And the question poses, especially if the data controller believes that serious harm may be brought by the data subject to its employees. So any points about serious harm?
Yeah, on that one, it is very, very difficult. If you're going to invoke that exemption, as the rules are that you have to tell them which exemptions that you have invoked, you don't have to necessarily link it to the specific information at that time, and there may be reasons not to do so. But it's all in how you put it forward to them. You can list out the exemptions. Serious harm it's quite a significant exemption. It is very, very rarely used. The only times I have actually seen it in action is where there has been a patient who has been looked at for their own data, and there are references to serious mental difficulties or historical things, or a third party has told the doctors about something that hasn't been disclosed by the patient, but the doctors do need to know about. So it's all based on relationships at that point. It may be best at that point, if you have a patient like that, it may be best to hand over things to them in person so that they can discuss any questions that they have. There's a lot of it's in the wording, but if you are invoking the exemption, they do need to know.
Okay, and difficult, and some thought needs to be given in those circumstances. Thanks both. I'm kind of going to put a bit more of an employment slant on things now in terms of just looking at the employment context in a bit more detail. So first of all, why do employees submit data subject access requests, and what are the circumstances in which they make those requests? And in any event, why is that relevant? Helen mentioned in her session that a DSAR is what is known as purpose blind. So note that people don't need a reason for making a subject access request. That said, the underlying motivations of the person making the request may be useful to know, so particularly in an employment context. And one of the reasons for that is, well, how will the employee respond to what they receive? Will the DSAR have implications for the ongoing employment relationships? How will it impact on any processes that are underway? So controllers or organisations should obviously consider the context within which a DSAR is received. Just expanding on that, is the data subject annoyed with the organisation as their employer, or are they starting a fishing expedition for evidence so that they can actually bring complaints? Well, on that, it is a legitimate use of a DSAR to try and seek information that would help bring a complaint or even litigation. The question for the organisation that arises is how you comply with the DSAR without adversely impacting your position from a litigation perspective? And that's really a tactical question, one that we have to grapple with quite often. Another point that's been made here, that we've been made earlier, is the right under a subject access request is to data. It isn't actually to documents. And so if it appears when you get a subject access request that the sole or the dominant purpose of that subject access request is actually to obtain a particular document for the purpose of a claim, the courts have indicated that that could be a factor for refusing. And the reason for that is is that the more appropriate forum to obtain the documents, and probably one which protects the documents from being misused, is the court procedure itself, or the court procedure for pre-action disclosure. I mean, whether you'll be able to rely on that kind of approach obviously depends on how the subject access request is phrased. And again, just looking at kind of motivations for submitting DSARs. So has something happened to cause the employee to distrust the employer? In one case, we saw the employee shared his name with another employee, so let's call both of them John Smith for these purposes. And due to basic clerical errors and a lack of care, his employment record had been mixed up with the data of the other employee, and that actually affected his employment prospects. And he tried to get the issue resolved via numerous complaints, but no one at his employer took ownership of the situation. And so ultimately, that person just lost faith that the organisation would sort the problem out. So that was the reason for his subject access request. You're forcing the organisation to properly review both of the employees' records, split them out, and take steps to prevent that issue arising again. And then perhaps there's some sort of kind of fear or apprehension underpinning the request. So, for instance, are redundancies on the horizon? Is the person making the request trying to get ahead of the game? So that's another reason. And then, is there a situation brewing that's causing the employee dissatisfaction and which HR needs to get a handle on quickly? That can obviously be the backdrop to a subject access request. And then, is the person acting vexatiously or maliciously? And that is obviously sometimes some of the motivations for making a request, particularly if there's a kind of pattern of complaints. And then you might be skeptical about this, but maybe someone is just curious to see what data the organisation holds in relation to them. I mean, I'm massively skeptical in relation to that, because most of the DSARs I see, that some of the reasons I've just alluded to. But just going back to the point I made at the beginning, when you can identify the context and the motive for the DSAR, that can be of assistance to you in narrowing down any searches that need to be undertaken, and also suggesting reasonable limits to the disclosure. Responding to a subject access request in a vacuum, if you like, is possible, but the more information you've got about context and motive, I think you'll probably do a better job and with fewer resources. Just want to talk now about HR processes and DSARs on the next slide. So of the kind of list of trigger points, if you like, that might lead to a DSAR, in my experience, it's really the kind of handling of grievances or dignity at work investigations or disciplinary investigations or performance management processes that could lead to termination that we see appearing as the backdrop to requests virtually, in the vast majority of cases. So employees who have been or perceive themselves to have been hurt, victimised, unfairly accused, but even fairly accused, reprimanded or terminated, they often use subject access requests as a kind of outlet for their feelings and really as a way of doing something immediate that requires a response from their employer. So that's what we see as a big driver to lots of subject access requests. If the employee doesn't get the outcome they want, they think the outcome was unfair or inadequate, one way of mounting a challenge to their employer or getting back at their employer is making a DSAR. And so in those types of situations, it's really it's important to consult with your legal advisors about how the relevant internal procedure that's kind of underway and is being operated, how that's going to be impacted by the DSAR. What are the implications of the DSAR for that process and the timings within that process? For example, I often see subject access requests made in the middle of a disciplinary investigation, and the employee taking the stance, well, look, until you've responded to my DSAR, nothing can happen. I'm immune. I've got a shield. I'm protected from any kind of disciplinary process continuing. And you need to place this disciplinary investigation on hold pending my getting my reply to my DSAR. And in my view, it would be an exceptional case that would require an employer to have to do that. Subject access requests, that they don't displace or trump employment law or good relations practice, they sit alongside it. So I had a case recently where the employee was accused of sexual harassment by a number of females, and the employee's case was that there was a conspiracy to make unfounded allegations against them. And so they made a subject access request, which they said would lead to all of this evidence emerging, which would provide evidence of the alleged the conspiracy. And they said that all these disciplinary proceedings should be put on hold until the subject access request had been responded to. But in this case, the employer had carried out a thorough investigation. Witness statements had been obtained from the complainants. Witness statements had been obtained from others who'd seen the complainant's behaviour. The employee fully understood the nature of the allegations against them. And if you put that in an employment law context, the situation was the employer reasonably believed that the employee was guilty of the misconduct. The employer had reasonable grounds on which to base that belief, and the employer had conducted a reasonable investigation. So our advice there was that fairness and reasonableness, that didn't require a delay or postponement to the disciplinary process just because of a subject access request. And as I've said, it would be an exceptional case, I think, that would require an employer to have to do that. And that kind of reflects the approach that tribunals take. So I'm obviously often in an employment tribunal where you get to the first preliminary hearing and the employee's saying, well, this is outrageous. I put in a DSAR, it's not being responded to, or it's not being responded to properly. How on earth can I conduct these proceedings? And the judges, employment judges, deal with that in a fairly preemptory way, which is not my problem, Gov, really. And they say, well, you might want to go and speak to the Information Commissioner about that. I don't have jurisdiction to deal with data protection disputes, and they're normally pretty firm, and well, they are always firm and robust in that respect. And then just staying with disciplinary investigations, and another kind of issue that I wanted to raise is the issue of where an external investigator has been engaged. As you know, that's often the case for a variety of very good reasons, but there are GDPR issues that arise, particularly when the instructions to an investigator are unclear or they're incomplete. So first of all, if you are going to use an external third-party investigator, you should ensure that there's a contract and agreement in place with that investigator that makes clear each party's responsibilities under the UK GDPR, and also deals with how personal data is going to be shared between the third-party investigator and the organisation. And in particular, it's important to be aware that if the investigator is taking on the role of data controller, if the investigator receives a DSAR, they're going to have to respond to the DSAR themselves. And your organisation or the organisation that's engaged them won't have any real say in how they respond to it. And that can potentially be problematic. Claire's talked about how exemptions may be applied, and there's inevitably an element of subjectivity in relation to that. And so the third-party investigator might hand over documents unnecessarily that you wouldn't have handed over. You may have applied an exemption. And the third party isn't going to necessarily be operating from the same perspective as you and with the same priorities that you have. So that can cause difficulty. So do think about GDPR and data subject access issues when you're contracting with third-party investigators. And then another issue that we see in an employment context is taking notes. and how you deal with notes in the context of a DSAR, and that's on the next slide, please. So what about the issue of taking notes during an employment process and in the kind of context of DSARs? So there's no strict legal obligation on an employer to take notes at disciplinary or grievance hearing. But obviously it's best practice to do that, and it has many advantages for the employer. In particular, tribunal would question why no notes have been taken if there is a subsequent tribunal claim. I think not having contemporaneous notes would make defending a claim much more difficult. There's a reference in the ACAS guidance that an employer should make sure that someone takes notes. So the reality is that notes will almost certainly be taken of internal processes. So the issue of relevance for today really is what does that mean in a DSAR context? Well, any notes taken, whether they're handwritten, in a notebook, a typed minute, or even a transcript created via Teams, they're going to be subject to UK GDPR, and a copy of those documents may need to be disclosed depending on whether any exemptions apply. So I think in order to ensure that your notes are fit for purpose, there are a couple of steps and options I think you should consider. So first of all, what do you say about access to investigation data and documents in your policies and procedures? Who's allowed to see those notes, what and when? That's something that I think you should deal with in advance in your policies and procedures. And then what about the basis upon which people who are participating in the investigation give information? What have they been told? So we often see employers or the investigators promise witnesses that their evidence will be kept confidential, without any exceptions or qualifications mentioned. That's not really helpful, and that can cause significant problems later on, particularly if a DSAR is received, because you've got an individual asking for their personal data and another individual whom you've promised you'll keep what they've told you confidential. So one recommendation is that shortly after any interview, the note taker prepares a single final version of the minutes, considers sharing them with the interviewee for their comment, but not for their approval. And then that final version, along with any comments from the interviewee, are stored for later reference. That's going to be compliant with data protection principles, and then earlier drafts and notes could be considered for destruction or erasure, but just bearing in mind your potential obligations to disclose in an employment tribunal. And then this point about automatic transcription of, on services like Microsoft Teams, it's increasingly being used, but there are some words of caution that we make in relation to those. Quite often the transcripts are inaccurate, they can be repetitive, and they can fail to kind of accurately record meaning, as the transcript itself doesn't account for intonation or facial expressions. And in order to comply with the GDPR principle requiring data accuracy, someone will have to be assigned to go through each of those transcripts and correct it. And transcripts can also be extremely difficult to deal with if a DSAR submitted, as their review and redaction can use up significant time and resources. So, and then for the final point there, just about commentary, and I appreciate this is difficult in a HR context. Any notes that you're taking should really concentrate on facts which prove or disprove any of the allegations, rather than kind of ancillary opinions or commentary, because that's just going to potentially be problematic. It's not needed, and it's going to be potentially problematic in it if a DSAR is made. So just on to my next slide. So we're coming to the end of the presentation. There will be some time for more questions at the end, but just to reiterate some key messages from this morning's presentation. So first of all, DSARs are purpose blind, but context is key. You'll want to understand the background and the requester's motivation, because doing so will help you focus in on what they want, might even give you an opportunity to engage with the requester such that they don't feel that they need the disclosure. You know, I'm an optimist, we should see, but they're purpose blind, but understand the context. HR processes are frequently a trigger for DSARs. We all know that. So be mindful of how you process any personal data during those processes and ensure that you comply with data protection principles. Keep quality notes, and then be clear on the potential exemptions that are available. And in particular, if disclosure of personal data may have implications for the organisation because of litigation or potential litigation, or for others in terms of employment relationships and ongoing employment relationships, don't just disclose the data without looking to see if an exemption fits, or considering how you're going to manage the consequences of the disclosure that's made. Over disclosure can obviously cause problems. And then just repeating that point about consequences, keep an eye on the risk attached to any disclosures and anticipate and prepare for the consequences and implications of any response to a DSAR. Don't just send the DSAR response off and then wait for the kind of explosion to occur. Be prepared for it and anticipate how you're going to manage and mitigate the consequences. So there's some key points from today's presentation. I think we have got some questions. I'll just have a look at what's come through. I've talked about digitally recording meetings. I'll come back to that. Here's a question. So in terms of data subject access requests involving trade union representatives, specifically when using the data controller email address, are there any exemptions to disclose to the data controller? So I'll try and put that in context. So employees will often frequently be accompanied by trade union representatives. Trade union representatives will frequently be copied into correspondence with the employees. Any kind of points or observations in a DSAR context in relation to that? So in relation to trade union reps or employee or representatives generally?
Yeah. So with trade union representatives, any emails that the trade union representative is receiving or is sending as part of their trade union activity are trade union emails. They're not the emails of, say, the NHS Trust or the employer or anyone else. And so generally they do follow a procedure where they label them appropriately, and it's very, very clear. And they file them to make sure that they are segregated from the rest of their emails. Because the data controller, if it receives a DSAR, shouldn't be looking at those trade union emails, and actually to access the trade union emails, the requester would need to go and ask the trade union for them. It can be difficult, especially if people have failed to do their labeling properly and failed to do their segregation properly. You may occasionally come across one. If you are doing a review and you do come across emails that the trade union rep has in their trade union capacity, they need to be put to one side and not looked at and just, hived off. And then the trade union rep needs to be told to label things properly in the future. But to the extent that they are simply copied onto an email that is also going to the employee and also going to managers and things like that, that doesn't prevent those emails from being disclosed.
Okay, thanks, Claire. And then staying with trade unions, and at this time the BMA. So the questioner says, the question that I've been asked is about the inclusion of emails, so presumably in the response to the DSAR. During a specific case, the consultant, who was a named person in the DSAR, was requested to provide information, but they were asked to provide copies of emails from their trust account. But that consultant said the BMA had stated to them that they were personal emails and not business records. So do we have any thoughts on that? So my thoughts are that if the consultant's sending data on their trust email account that meets the definition of data, it's going to have to be disclosed, but I'll defer to you guys.
I mean, generally, yes, it would need to be disclosed. They're not personal emails. If you've been given a trust email address and you're using it for the business of the trust, those are trust emails, and the trust should be able to access them and include them as part of the SAR. To the extent that the consultant has also been using that email address for personal purposes, then they should be following normal procedure. You are allowed to use your work email address for some personal means, but you should be labeling it as personal so that those emails can be removed from any subject access request. I suspect in that case that the BMA guidance wasn't quite as the consultant was portraying it. I'd be very surprised if it was, and I would be expecting to challenge that position.
And then another question. So during my kind of bit, I was talking about this point where an investigation's being conducted, people are interviewed, and they kind of give their information often at length and containing lots of personal data about the employee who's the subject of the investigation. And so, I mean, I kind of highlighted the problems of promising confidentiality to those individuals. There's a question there. With an investigation, do you need to make sure that witnesses are told that what they say may be disclosed? So do you expressly need to say that? Any kind of do you want to expand on what I'd said about the difficulties of promising people confidentiality?
Yeah, sure. Unless you want to do it, Helen.
No, go ahead, Claire.
Yeah. The problem that we often come across is that a witness is told, oh yeah, just come and tell us what you need to tell us, and it's all completely confidential, and we won't disclose it to anybody else. And that's what they take away from that meeting. And the problem with that is that if this is an interview with them for the purposes of potentially taking action against another employee or making a report to somebody else, you can't promise that level of confidentiality. But once it's been promised, that's what they expect, and a duty has arisen, which means we then start having to look for ways to get out of that duty. And there are three main ways of getting out of a duty of confidentiality. One is that the person who you promised you'd keep it confidential consents, which they're probably not going to do, or you have to find a legal obligation that means that that overrides the duty of confidentiality, or you have to find a substantial public interest. And believe me, the case law on substantial public interest is not pretty, and it's all very, very difficult to do. So the best thing for you to possibly do is at the start of any investigation, make sure it is very clear what the witnesses are told, and that needs to be, what you're telling us is for the purpose of the investigation. We're clearly not going to disclose it beyond anybody who it's necessary to disclose it to for the purposes of that investigation. But we can't promise you that what you have said won't go to the person you've accused of something, because if we're going to take action against them, we're going to have to tell them what case that it is that they're answering. And anything that is told them is, what's best to do is to write essentially a script for this at the start and make sure that essentially the script is read out so that you have a written record of what they were actually told.
Thanks for attending this morning. As I said at the beginning, once the webinar ends, you'll be asked to give some feedback, and we massively appreciate your doing that. So thanks very much for attending, and have a good day.